Great. There we go. Okay. Thank you everyone for joining the presentation today. I'm Shawnee Collymore. I'm an attorney here at Cody McCarthy. I've been practicing estate planning and elder law for about 14 years. And Denise has been practicing for about the same amount of time.
Hi, I'm Denise McCarthy, partner here at Cody. Thank you everyone for joining us this morning for our last presentation in this series, which we'll have to do it again because quite a few people have signed up to do it. Well, maybe next summer.
Maybe we'll do a winter series.
Yeah, that's a good idea. New topic in the winter.
New topics, yeah.
If anyone has any suggestions for topics or things that are, lots of common questions, it's kind of how we pick the topics. So if you've got anything, just shoot us an email, let us know.
Yeah, that's a good idea. If you have anything you want to learn more about, let us know. So today we're going to talk about avoiding and simplifying the probate process in Massachusetts. As a lot of people can get confused about what probate is and what the whole process is. So probate is a public process in which somebody who's passed away, their property is administered by the court. So this can happen if you have a will or you don't have a will. Essentially, the court ensures that if you have a will, that the decedent's wishes outlined in the will are followed appropriately, and the court appoints a personal representative, more commonly known as an executor, that is in charge of making sure the person's assets go accordingly. So that's the general idea of what probate is when people refer to that. Probate is generally only necessary if the person has probate assets. And a probate asset would be an asset that was in the decedent's name individually with no other person, so not a joint bank account, and an asset that doesn't have a beneficiary. So think maybe like a good example would be a bank account, like an individual bank account that didn't have a beneficiary on it and is just in that person's name. That would be a probate asset. Or if you owned a home and you didn't own it in a trust or with another joint owner, that's a probate asset. So when somebody dies with assets like that, the only way for your loved ones to gain access to the assets is to go through probate. So that's the whole, that's why probate can be necessary. So it really just kind of depends on what kind of planning you do in advance.
I just want to underscore one thing that Shawnee already said, but it's hard with these Zoom presentations because you don't get this. But when I used to do presentations in person a lot, I feel like there was always this collective gasp when we tell people that wills go through probate. Because I think there's a lot of people that really think that probate is only for the people that didn't put together a will. So that's really important thing to catch if you miss that, is just wills do go through probate. They're kind of like instructions that need to be authenticated before they can be used. And we will touch on how trusts can be used to avoid probate. So I just want to make sure that everybody's clear on that. Will or no will probate.
Yeah, that's really good. A lot of people do think that, oh, well, I don't have to go through probate. They say that all the time. I don't have to go through probate. I have a will. Right. So I'm like, yeah, that's exactly why you do have to go through probate. Right. So a will is just giving the court the instructions as to like who you wanted to be your executor or personal representative and who you want to get your property. So if you do these instructions, the court will follow them as long as your will is valid. And if you don't have the will as your set of instructions, you didn't do a will, then the court has statutory rules that govern who gets your property and who will serve as your personal representative. So by doing the will, it's just that you get the power to decide who those people are. And if you don't do a will, the state basically decides who those people are. So that's like the big sort of difference there. So there's different kinds of probate. I don't want to get too detailed into it, but there's essentially three forms of probate: a formal process, an informal process, and a voluntary process. The voluntary is the quickest process, but it's it's only reserved for estates that are $25,000 or less, plus the value of a car. So it's for much smaller estates. So if you just have a few things that you need to access, that's when you would use a voluntary. Most of the time, we do a lot of formal probates, which is a little bit of a longer process. And you might do this if you have real estate, or if you have any situation that's sort of not like cut and dry, you're going to want to do a formal probate. Or if you need like a formal determination of heirs for various title reasons, you might do that. An informal would be the second sort of fastest option. And we do that process as well, just kind of depending on the client's situation. So generally, from when you file your documents for a formal or informal sometimes process, it's going to take like 2 to 4 months to get your personal representative appointed. So that's kind of good to keep in mind. It's not like a super fast process. So it does take a couple of months. So during that time, any probate assets would be sort of frozen. You wouldn't have access to the probate assets while you were waiting to get appointed. Okay, so we kind of touched on this, but if there's if you don't have a will in Massachusetts, your heirs are determined by the Massachusetts intestacy rules. So the downside there is that, your property might not necessarily go as you would have wanted it to. So that's why it's really important to have a will. I know sometimes I have clients that say like, oh, my mom didn't have a will, but she told me what she wanted. But sometimes like what your mom told you she wanted is not what you're allowed legally to do, because when you go through the intestacy rules, it lists different people. So like if you have stepchildren that you want to inherit, your stepchildren are not going to be considered heirs if they weren't adopted by you. So that's a big thing for people. Or sometimes people aren't close with their biological family, so they want to leave assets to other people that they consider their family. And you also cannot do that if you don't have a will in place, or beneficiary designation. So it's really important to kind of think about those that process. If you do have a will, like I said, it governs who's going to serve as your personal representative and who's going to inherit your property.
And one other thing too, that I caught a client trying to do this week too, where they're like, oh, I'm just going to do what mom said she wanted. People don't think about gift taxes and that there are gift tax consequences. Yeah. You can't just willy-nilly give away assets. There are repercussions. Particularly on the federal gift tax side. But when you gift and just try to give away assets, it impacts your exposure to the Massachusetts state tax. So it's not something it's just inappropriate to do it that way for a whole host of reasons. And I think people kind of are lax in their minds about following, because they feel like they're doing the right thing. And I get it. Yeah. It's following the wishes. But I have literally been in the probate court and watched someone be shackled, taken to jail for mismanagement of probate assets. I mean, obviously she was just like keeping the money for herself, not giving any to her brother. So like a really bad situation. But I think people forget that when you are in probate, you are under the court supervision in every administrative task that you're taking. So you do need to do it right.
Yeah, that's true. I've seen people be jailed too. Norfolk Probate Court has a jail in the basement, guys, has 2 cells. I've seen it.
That's exactly where that lady was headed.
It's very unpleasant. So,
not to scare you, but follow the will.
Yeah. But mainly that happens like if you don't pay your child support or something, is most of the time in probate court when you get shackled. But yeah. I digress. Okay, so another thing to kind of touch on what you said is like sometimes a lot of clients will say, oh, well, I'm just going to leave everything to my daughter, Jenny, and Jenny knows that to split it up amongst all the siblings. And they'll do that like with IRAs. They'll just leave everything to that one kid. And then the kid's supposed to like, I don't know how you divide an IRA, cash it all out or something. So it's just kind of crazy. So some people don't think, like you said, about, okay, in order for her to now, who inherited the IRA, to give it to 3 other people, she has to cash out the IRA, and she's going to be taxed on all of that money and then divide it. And, you know, sometimes it's just, and it's like, can be a burden on her. And like you said, now that person's made a gift, and, you know, depending on what their net worth is, that could be a problem for themselves. Plus, like, sometimes people go through things and they're not able to fulfill the parents' wishes because, like, maybe now they're getting divorced or something, and now they can't, you know, and the spouse isn't allowing them to do that. So it's really always better to, like, have your will or trust reflect your actual wishes.
Yep. Yeah. And there are, you know, sometimes it's, oh, you know, I'm worried about that kid is getting divorced, or I hate the in-law, or there's, you know, people have really good reasons for doing that kind of stuff. But we're here to tell you that proper planning, we can do that we can address all of that for you. There's a way to leave money to people without leaving it directly in their control. That's really, you just invented a trust, is that's, you know, something you're thinking of. That really is what they're used for. So you meet with your estate planning attorney if that's resonating with you.
Yeah. Okay, so just to have a brief understanding of how probate process works. For a formal proceeding, what is going to happen is you have to file for any of these things. You need to file within 3 years when the person died. After 3 years, you're limited in what you can do with the court. So it's important to come right away after somebody's passed away and meet with your attorney to figure out what steps you need to take. Sooner rather than later is always best. And there is technically a rule that you're supposed to produce the will within 30 days. So what you do, you meet with your attorney. The attorney is going to prepare a formal petition. If that's been decided that that was the appropriate thing to do, they're going to file that along with your original will and an original death certificate with the court. And then what happens is the court issues a citation to your attorney, and that citation must be served upon all of the interested parties. So, like, all the person's children and anybody named inside the will to inherit must receive a copy of the citation that the court issued. And then the court gives you a deadline by when you have to do all of this. That's called a return day. It's usually like 3 or 4 weeks, so you have a timeline. And you also have to publish in the newspaper the citation. And then once you've done all this by the deadline the court gives you, you have to file a return of service, which basically just proves that you served everybody the court told you to. And then once you do that, your whole petition will go into the judge's box, and they will eventually review it in the order it was received. And if everything's in order, they'll approve it and they'll issue letters of authority, which will get mailed to your attorney. And that is what gives the personal, those letters of authority the court gives you, is what the personal representative has to take to the bank to now be able to access the bank accounts or sell the car or whatever they need to do. You need those letters in hand to be able to do that. That whole process I just went over is going to take 2 to 4 months, depending on the court, how backed up they are at any time, and how, you know, if you have any sort of odd situations.
I wanted to point out something about notice and who gets notice, because I think this is a really good reason why people will work themselves out of a will into a trust, because in the probate court process, you give notice to everybody that's named in the will, and you give notice to the people that are deemed to be your heirs at law. So your heirs at law are the people that would have received your assets if you had not put together a will. So when someone has no will, those are the only people getting notice. But if you have done a will, you may have named different people than your heirs at law as beneficiaries. Both of those sets of people have the right to get notice, because if the people that would have received if you had no will, they have legal standing to say, well, maybe that will's fraudulent, or maybe they had no idea what they were doing when they signed it. The reason I really dislike the way the probate court handles that is because they make it very, very, very easy for people to throw a wrench into the whole process. So the way the notice form reads is it says, this person's trying to be appointed as the representative of the estate. Do you want to object? And all they have to do is say, yes, I want to object. They send in a form, and then they get 30 days to justify their reason for objecting. But every attorney in the world asks for an extension on 30 days. And you can't, at that point, you're trying to, play nice and not elevate hostility. So you say yes. Now you're at 60 days. It all of a sudden you can't access the assets, and things start dragging on, and bills need to get paid. And sometimes it's not even, that somebody's going to file a legit legal claim against your state that you were, forced into signing the will. It could just be that this person hates the person that was picked because they're siblings and they're, ticked off about something that's been brewing for 45 years. You don't know what it is, but the whole process is very easy to get slowed down by any little thing. So the timelines that Shani is giving you are like best case scenario. And another example too, kind of shifting my point to that, is the probate courts in Massachusetts do guardianships, divorces, all of that stuff is all in the probate court. So if they get slammed with, 1 year there was a change in the way alimony was going to be taxed, so everybody's rushing to get divorced. So all of a sudden, everyone's trying to get divorced in this window. So then all the probates fall to the wayside. So there are a lot of things in the probate court that are unless you know, you don't know. So that's why we're here to kind of give you some warnings about that process.
Yeah, that's true. And it also varies county by county too, because every county can sort of run their probate court a little bit differently, and they all have different volumes. So that's important to keep in mind. During the formal probate process, you can request the court make a determination of testacy. That means whether the decedent died with a will or without a will, and you can the court will also make a determination of heirs and devisees. Heirs is like who the person's like kids are, that kind of thing, the natural people that would inherit from them without a will. And devisees is like who you've named in your will. So the court will make a determination of who those people are based on your filings. And that can only happen in the beginning during a formal process. That in an informal, they don't make a formal determination of heirs. So that's what that is. Then in the informal process, you also can file with or without a will, just like in the formal process. It's a little bit faster to get appointed as the personal representative. There's no formal determination of heirs. Now, that formal determination thing, that's going to be sort of important if there's real estate. So if you have real estate in your probate, you're going to want to communicate with your attorney about the best steps. I don't want to get into all that here, but there is a process whereby you have to make sure that you get good marketable title to your heirs, for your heirs to be who are inheriting the real estate to be able to like sell it in the future or get a mortgage and all those kinds of things. So there is like a little bit of a process that you have to do with the estate. So communicating with your attorney to make sure they understand those rules, and to make sure that whoever is inheriting the house has good title, and in someday in the future they can sell it and not have any problems later on. So that's when it's important to kind of figure out formal, informal, and all the closing the estate. Okay. Another side note, from beginning to end of when you sort of like open the probate to close it, it's generally going to be a year. And that's because creditors have 1 year to file a claim against a probate estate if they're trying to get reimbursed. So that's that they have to file something within 1 year. And then technically they're supposed to get a judgment against you in a court and then the personal representative has to pay the claim. A lot of times they don't do that second step of like actually getting a judgment against the state to get paid, but there is a 1 year deadline for that. So then after the 1 year period passes and the personal representative hasn't received any claims and you've administered the estate, you've given everything to all your beneficiaries, whatever, you can then close your probate. And closing the probate is, I know some people, you might think, oh, well, I've got all the money, I've distributed it. Why do I need to close my probate? I can just kind of move on. It is really, really important to do that to stop your, if you're the personal representative, your personal liability. from serving as the personal representative. And also it's important for real estate to be able to, that's one of the steps, final steps in ensuring that whoever got the house is going to have good marketable title to the house. You do have to close your estate in order to make that, to get that good title. So that's really, really important. Okay, so personal representative is going to be appointed in your will. And then if they are not appointed in your will, or because you didn't have a will or whatever, so then the state does have a list of priority for appointment. So if you died intestate without a will, they have an order. So of course, the first person is the person named in the will has priority to serve, or the person named in the will that was conferred the power to nominate somebody to serve. So in your will, you can also give somebody the power to nominate somebody to serve as personal representative. So that person would have priority. If you have a surviving spouse of the decedent who was also inheriting under the will, that person would be next in line to serve. After that, it goes down to other people named in the will to inherit. After that, it would be the surviving spouse. So that's different than before, because you could have a surviving spouse that maybe you didn't like name in your will, or you maybe because you didn't have a will, and any other heirs that you have, and then it just kind of goes down to any like next of kin after that. So if you don't have a will, you have to kind of go through that sort of list of people first who have priority to serve before the court will allow somebody. So if somebody passes away and they don't have a will, and you're like you're a child and not the spouse, you would have to have the spouse who had priority step down like and agree to let you serve before them, kind of thing. And then one other thing that I don't think I mentioned before was like, if you don't have a will, I mentioned that there was like a statute that will basically say who gets your property instead of if you don't have a will. Basically that is your spouse would inherit, and then if you have, assuming that you and your spouse have children or all of only that marriage, your spouse would get everything if you don't have any children outside of the marriage. And then it goes down, and if you did have children, it would then go down children, and then if you didn't have any children, it goes down grandchildren. And then if you didn't have any children or grandchildren, it's going to go to like your brothers and sisters, and then it goes down like nieces and nephews, first cousin, second cousin, down the line like that, until they find a relative that's living to be able to inherit your property. So for some people, that's like a natural progression of who they would want to get their property, but it doesn't work for everybody. And then some of the percentages change depending on whether you have children outside of your marriage to your spouse. So it can be split sometimes where your children will get some and your spouse will get some of the property. So it can be very complicated. And like I said, and some people have stepchildren, and the stepchildren are not heirs. They don't receive anything. So it's just really important to have a will so you can outline what you want and make sure that your wishes are fulfilled. Because I think the intestacy rules only sort of work with like really traditional families. If
they
you don't
tried
have a traditional family, it's not really appropriate.
Yeah, it really was designed really for like the traditional nuclear family, like two parents, all the kids come from those two parents. And I mean, you gotta appreciate what they're trying to do. So they're basically trying to do like a one size fits all estate plan for every family scenario. So definitely, if you're a second marriage or children from prior relationships, you cannot rely on the intestacy rules.
Yeah,
and honestly, most people deviate from them anyway.
Yeah. Even people sometimes who do have traditional families,
right.
Sometimes clients are like, oh, my brother, oh, I don't want them getting my money. I haven't spoken to him in like 5 years, you know? So
yeah. So
really, really important.
They're there in case people don't do well, but they're really not meant. They're usually not what our clients are using to or would want to use to pass assets.
Yeah. Okay, then the voluntary, which I touched on. So that's if your estate is under 25,000 or less, plus the value of any car, you can do a voluntary. It takes maybe like a week, and then you don't have like a formal personal representative. You have this like voluntary personal representative that only has power to be able to like get the money out of the bank account, essentially. You can't you don't have really any other power, and then you're supposed to sort of distribute it to the people named in the person's will or via the intestacy rules to whoever was entitled to the property. So it's just sort of like a quick process for smaller estates to make it like less burdensome on people. Any interested person can file the voluntary, so that means heirs, devisees, kids, spouses, creditors, beneficiaries, anybody like that can could file the voluntary administration to get appointed and access the funds that were there. This happens a lot sometimes, like if there's like a person died and they just have like a car, we might do a voluntary, even if they, have a trust, because it's kind of a pain to have a trust on like your car, that kind of thing. We might do a voluntary to get the car moved over.
Yeah, or sometimes people have, gotten everything into their trust, but they forgot one little thing.
Yeah.
They didn't even realize that they own shares of this company.
Yep.
That's kind of nice that we have that as a quick, so much less expensive option for those out there.
Yeah.
And you can, between spouses, transfer a vehicle without having to go to probate. So if it's just the past, you don't even have to bother with the voluntary. So
that's true. Yeah, and if you use an insurance agent, you can just call your agent and your insurance agent, and they can help you with all that process. Okay, so that's the general probate process and kind of like how that works to administer your property. One other thing I want to just sort of point out is that probate assets, like I said before, probate assets are just assets in your name without a beneficiary, not a joint owner. So that means like if you do have a will and you have like a life insurance policy or you have IRAs, those type of assets typically have beneficiaries named. So you're going to have a beneficiary designation that says who you want to get your property. When you do your will, you're going to also say like who you want to get your property. Your will does not govern who's going to get your life insurance or your IRA. So sometimes people think like, because like sometimes people will have an IRA and they'll have, whatever person, some kids named on there, and then they do their will and they update the percentages of how they want their kids to inherit, and they think that's going to automatically change who's going to inherit the IRA. Those are totally separate. So your will does not govern your IRA beneficiary designation form. It would only govern if you had no beneficiary, and then it would become a probate asset, and then it would then your will would govern it. But typically we recommend people to fill out their beneficiary designation form. So if you do update your will and you're changing who you want to inherit your property, you do need to remember to update your beneficiary designation forms, or even to just like check like what you put, because sometimes people fill out those beneficiary forms like years in advance. I know like life insurance, I know even my own parents, like my dad had life insurance that he got like when he was single, and it had his sister on there, and so it's just like sometimes you forget like what you even put when you had some life insurance through your job, and like things change, and then it's like 20 years later and you haven't like really gone back. So it's always good to go back and check who are your beneficiaries on those types of documents.
Someone asked a question, so I will respond to that since it's like in the context of what we're talking about. The question is, does a house with a transfer on death have to go to probate. So I'm pretty sure what you're talking about is like a life estate deed,
Yeah,
because that's kind of the equivalent of a transfer on death. You basically automate, okay, I'm going to own it for my life, and then immediately when I pass away, the remainder interest in that property will fall to whoever it is. Those don't go through probate, so that has or bypasses probate. What I was starting to think about, because I think we're going to touch on this, I guess, a little bit later too, about beneficiary designations, but I'm not a huge fan of I call it kind of like poor man's estate planning, because I find it all the time where financial advisors are like, oh, the insurance policy has a beneficiary, the retirement account has one. Let's just throw one on the brokerage account, and oh, just put one on all your bank accounts. And then the second you pass away, yes, you've bypassed probate, but you just gave away all of your assets to whoever you wanted them to go to. But there are costs associated with you having passed. Someone has to pay for your funeral. There might be estate taxes. That's the big one. And if you just give everything away, now you've got this person named that's going to have to do all the administrative work. They've got no way to pay the bills. And they're chasing people for money. And if there's real estate that needs to be sold, there might be improvements that needs to be made. There's going to be closing costs. There might be title issues that need to be sorted out. Whatever it is, now that person's chasing people for money. So I would say just don't get excited that, oh, I can put a transfer on death on everything, and stop listening to what we're saying, because really the trust is the better vehicle to bypass probate. So Shawnee's going to go into all that now.
Yeah. Yeah, and yeah, it really every estate plan is customized based on the person's situation. So like Denise said, it is really it's not like a one size fit all solution for everyone. So if you sort of would like to avoid that whole prior 30-minute discussion that we just went into about probate and don't want to get into that at all, then this second half is for you. So if you want to avoid having to go through that probate process, the ways that you can do that are by having, number one way, having a revocable living trust that you can transfer all of your assets into. And essentially, a revocable trust can own anything that you can own. You can transfer into your trust. And you can also avoid probate by having updated beneficiaries on all of your accounts and transfer and death designations on your IRAs and life insurance. That's important. Or by having jointly owned assets. So if you're married, typically we recommend for like your bank accounts, that you're gonna most of the time want them to be joint with your spouse. Those kinds of things avoid probate. But like I said, for all of these things, it is client specific. So, for some people, some of these options might not make sense. So essentially a revocable trust is like a will substitute, and it's going to state how you want your assets to pass at death. But instead of a personal representative managing all of your assets, you're going to have a trustee that manages all of your assets. So some of the terminology sort of changes a little bit. For a traditional revocable trust, for a married couple, you and your spouse are going to serve as trustee of your revocable trust while you're alive. And you're retaining control over all of your assets, just like you do now. And the trust is amendable, changeable. You can, and typical things that we're going to put in there: your house, we're going to do a new deed. We're going to transfer your real estate to your revocable trust. That's a big asset that causes clients to have to go through probate. So we're going to want to avoid that process. So you're going to be your own trustee while you're alive, and you're just, doing whatever you did before, essentially. The only time anything would change with your trust would be if you became incapacitated and could no longer continue serving as trustee. Then your trust document is going to name somebody that's going to step in and become the trustee for you, somebody that you've already chosen and feel comfortable managing assets for you while you're incapacitated. And then when you pass away, that person or another person is going to step in as the trustee. That's going to sort of like wind up your affairs, pay any estate taxes, and pass assets to your beneficiaries, whether that's outright, in trust, all those kinds of things that you should have spoken with your attorney about. about how you want your beneficiaries to receive their inheritance.
The way I just want to go back to will versus trust. The way I always explain it to clients is wills are just instructions. It's just, here's what I want to have happen when I pass away. You just leave all your assets the way they are. And then you've got this will that's going to be used when you pass away. The trust is an entity. So it has your instructions in it, but you're going a step further and you're creating an entity. So when you're alive, it's just another way for you to title your assets. So I think of it sometimes like your own little personal business. It's like an extension of you where you can put your stuff. Because I think it's important because it kind of clicks when you understand the mechanics of why it bypasses probate. Because if you can take all your assets and have them owned by your trust, the entity, you've got full access and control your whole life. The second you pass away, you don't have assets frozen in the name of a deceased person like you do. That's what triggers probate. Instead, the entity has survived. It always survives you because it can't die, right? So all that's happening is a change of guard. You've got a new manager stepping in to take over. So mechanically, that's how it works, is because the trust is the owner, not an individual, it just seamlessly continues to move forward.
Yeah, it is a lot more seamless when somebody's passed away. So like if you had a trust, your kids are going to call us and say, oh yeah, mom died last week, what do we do? And then we the first thing we do is like prepare the paperwork for the successor trustee to accept their role as successor trustee. And that's just something we do in the office. It's like a 2-page form and they sign it, and then they can submit that to the bank and whatever to show that they're the new trustee. And then they instantly have access to that trust assets.
And that's honestly even really a formality on our end. You could take a death certificate and the trust, so they have your binder with all your documents that we would have put together. They could take that to the financial advisor and say, I need to access this account, and they are the trustee. We do a document appointing them as such, but it really is seamless, and it is a very, very different phone call when we get on the phone with somebody who's just lost a loved one. Because one of our first questions, is what kind of estate plan did they have, and do you have access to money? The people that don't have access to money because they're tied up having to wait in this probate court process are panicky because they're going to have to pay themselves, so they're going to have to use their own cash to float the cost of your real estate or whatever the heck needs to happen in your world. The people with trust, we can very quickly talk them down and say, okay, you actually do have access to money. Let's just, really quickly tell you how. It's just having done it for so many years, it's just a much better, smoother people are grieving. It's not like it's a nice time anyway. So to add more stress is really not lovely.
No, you've got to wait 4 months to
right. Miserable, and let me make you more miserable. Yeah.
Oh, that's true. Okay, so we've kind of touched on some of these things. The revocable trust, it avoids the probate court process. There's no court filing fees, so people do like that. And it's not public, because when you file your will with the probate court, I don't know, people might not know this, but when you file your will, that's public. So anybody technically can go down to the court if they don't have anything better to do in their lives and read your will. I don't know why they would, but they could. So, some people don't like that. It's nice to keep that
because people do that. There's companies that do it, because I've gotten calls when I'm serving as the personal representative for people looking to try to purchase the property in the estate, or
I get those calls too.
A realtor. So there are certain
those letters like, let me buy 123 Main Street. You're the PR.
Right, and you're thinking, how the heck did they get my info? I know. Not realizing that the probate court is totally public.
Yeah. Generally, if you do a revocable trust, they're going to be a little bit less fees, potentially. Doing a trust up front is going to be more expensive than doing a will generally, but going through the probate process is going to be more expensive than the cost to do the trust. So it can sometimes work out to be a little bit cheaper depending on your situation and what needs to happen if you do a trust in the long run. And trust also can minimize estate taxes for people, which generally people don't do in a standard will. And you can also create sub-trusts, continuing trust for your children. If you're concerned about protecting their inheritance, maybe they are going to go through a divorce or they're bad with money or whatever. So you can do asset protection for your children if that's something that is of a concern for you. So that's always nice as well. So on the estate tax front, most wills sort of just like leave everything to their spouse, and then it's going to say, I leave everything to my spouse, and then if my spouse isn't alive, I leave it to my kids. So that really doesn't do anything for reducing estate taxes. You're really sort of like wasting the estate tax exemption of the spouse that died first when you do it that way. And because everything else that you just sort of left to your spouse is then later on, when your surviving spouse dies, going to be includable in their estate for estate tax purposes. So what a trust can do for like any sort of like basic estate tax planning is that it's going to create 2 subtrusts upon the death of the first spouse, a marital subtrust and a family subtrust. And we're allowed to fund those subtrusts with the family subtrust with up to the estate tax exemption amount in Massachusetts, which is currently $1 million. So we could set aside the first $1 million in your family trust for your surviving spouse, and then anything over the $1 million exemption amount would go into your marital trust, and that $1 million that we put into that family trust will never be included in your surviving spouse's estate when they die. So that's like out of the picture. And so depending on what other assets they have, you might totally escape paying any estate taxes, depending on the total level of your assets. But you've gotten that first $1 million out, and it could grow to be 20 million if you're a great investor. It's not coming back into your surviving spouse's estate for estate tax purposes. So you really can only do that via some type of trust. So if you are concerned with estate taxes, that would be another reason why you would want to consider a trust to try to mitigate any tax issues that you might have down the line. So that's trusts. Then the next, did you have something to add about trusts?
No, I was the only thing I was going to mention, because I'm looking it up right now because we still don't have an answer from our state yet about the exemption possibly going up.
Oh yeah, no,
so it is right now it's $1 million per person. There, it's proposed. I think the governor wants 3 million, but then it's looking like it might be 2. So it might increase. We should know within the next, I would say, like week or so. Because they have to wrap up the budget today, I think.
Yeah. So what Denise is referring to is that there's talk of, so currently what happens in Massachusetts is that we have a $1 million estate tax exemption amount. So that means when you die, if your total estate is over $1 million, and in Massachusetts, real estate's so expensive, so you could very easily cross that threshold just by owning a house, then you have to file an estate tax return and potentially pay a estate tax to the Commonwealth of Massachusetts when you die if you're over $1 million. And federal exemption is really high. It's like 12.9 million per person. So most of you don't have to worry about federal estate taxes. It's really Massachusetts because we have one of the lowest estate tax thresholds in the country. I think it's like us and like maybe 4 other states or something that have $1 million. But there's talk that they might increase that 1 million to 2 million. And I think there's just talk about how that would work exactly, whether you would be taxed on just what's over the 2 million when you cross 2 million, or if you cross 2 million, if you're taxed on everything. So I think they're kind of like trying, that point is another thing I read, they're trying to like figure out. And so we'll just see, we'll have to wait and see if it passes. Sometimes, you get your hopes up and nothing happens. So
that's kind of generally what's happened. But the revocable trust, if you've got an existing one, like Shawnee's just explaining how it uses both your exemptions, they're generally designed as formulas, so you shouldn't have to rush into changes because the exemption changed. So don't be that's good. So that's kind of a nice thing too about the trust, just kind of doing it
Yeah, it doesn't say anywhere in the trust that we draft $1 million. So if it changes, it still works out like Janice explained, because it's just a formula that's tied to whatever the current Massachusetts exemption amount is. So that, like she said, that's really good. So we'll have to see what happens with that, but I'm sure you'll see something in the news if it does pass. It'll be big news. So I guess we'll just all have to keep our fingers crossed on the state taxes. Beneficiary designation forms, that would be the second way to kind of trying to avoid probate, is to make sure things like your IRA, your 401k, your life insurance, that generally don't pass through a person's will. If you have a beneficiary designation, you want to make sure those are up to date and name the correct people, and that you filled it out. That's another big thing. Sometimes people don't fill out their beneficiary forms on those assets, and they go through probate mistakenly. So it's really important to make sure those are up to date and tied to your estate plan.
A common one that we see is husband had wife, or wife had husband. Spouses have each other as the primary beneficiary, and then one spouse passes, and that the surviving spouse doesn't have anybody else named. They never named a contingent, right? Yeah. And then they just forget about it. So what happens is it goes to your probate estate, because now it becomes this asset. It's almost like it had no beneficiary and you owned it. So they kick it over to probate. So you have a probate asset that you didn't even know you had. And something else to note on beneficiary designations is it's really important, because we do see this a lot, where people, their first round of their estate plan was their friend from law school or their buddy that drafted this will for them. You can't really work like that, because you need an estate planning attorney that's going to sit down and figure out what you need and then look at everything. Like we would sometimes, people with revocable trust, some of the beneficiary designations, we're advising them, okay, make it your spouse, but then make it the trust, because the trust has protective provisions for the kids. So you're going to want these assets flowing to the kids in a certain way. So that's why, again, I'm not a huge fan of the just throwing on beneficiaries. Oh, look at me, I bypassed probate. Because bypassing probate, yes, is important, but it's you really are planning, looking at the big picture and looking at how everything passes. And okay, once it makes its way to who it's going to, can we do better? Can we protect it? So in case they get divorced, this money would stay with the kid. So you really want someone looking big picture. So plug for estate planning attorney. That one. But it's true.
Yeah, the contingent beneficiary thing is a really good point, because sometimes people just put their primary person and they're like, okay, I'm done.
Yeah, I'm done. I did it. Yeah.
Yeah, I did it. Yeah. Yeah. You need a contingent beneficiary, which if you have a traditional family, it's your spouse primary, your kids contingent, like, as a minimum, or whoever. Another way to avoid probate is to have joint assets with your spouse. So that could be another way. So I know some couples have accounts. Some couples like to have individual separate accounts. But if you do that, at least name a transfer on death designation on the account to be your spouse or whatever, something, so that as you have everything set up to go to who you want without having to go through probate. So kind of going through the list of all of your assets is a little bit of a task, but it can save you a lot of time in the future, not having to probate your will. So basically, in summary, how you can simplify probate is to make sure your will is up to date. Because even if you do have to go through probate, it's not the end of the world. But, if your will is 10 years old, or if it's the will that you got when your children were infants and now they're 30, that's a good indicator that you need to come in and see us and update it, and make sure that it now accurately reflects the stage of life that your family is in. That's number one. And make sure your family know what your wishes are ahead of time to minimize sort of hurt feelings. I know sometimes some families are leaving an unequal distribution to their children for various reasons that might be totally legitimate. Like maybe you bought one kid a house, or you did that, or I don't know, whatever. I think it's always important to speak with your kids about these sort of issues ahead of time, so that way they understand like why this happened. That can really minimize sort of any sort of fighting after the fact. If you've had a family discussion about your wishes regarding your plan, talk to your personal representative that you're nominating, or if you've named a successor trustee, talk to them and let them know, hey, I'm nominating you to be my personal representative or successor trustee when I die. Because sometimes people pick a friend or whatever as that person, and they never ask them before they pick them. And then the person's like, what? I don't want to do that, you know?
Or and tell them where you're keeping the documents,
Oh my
because
God, yes.
we get that question a lot actually in signing. What do I do now? Okay, so you have all these documents. You do need to tell either if it's a trust or successor trustee, or if it's a will, your personal representative that you've named, where you keep the documents. Everyone instinctively wants to put them in a safe. We actually, for our clients, hold on to the original will, so you have a copy of it, because I can understand that document, because it is, nice to know exactly where the original is. There literally is a process, because so many people do this. So there's this process in probate where you can file just to gain access to a safe deposit box to check for the will, because so many people are trying to hunt and chase wills. So you really need to make sure they know how to get it, because they can't access the document, they can't execute on your wishes and your plan, and they don't have the authority to do so without it. So it is important. And we like, for us, we keep a copy, like the trust, we keep a client's copy, we have a copy. So you would want them to know who the estate planning attorney was too.
And one thing on safe deposit boxes, if you are somebody that wants to keep your documents, your will or whatever in your safe deposit box, what I advise my clients to do is to add their kid that's going to be the PR, personal representative or trustee, as a joint owner on the safe deposit box, and then make sure they have a key and that the child has actually accessed the box at least once while you're alive. That's really important for them to be able to, that they have a key and they've accessed it before, for the bank to be able to allow the child to access the safe deposit box. So if that's something really you want to do
all the time, forget that that is a bank account. People think of it as like, oh, I have my bank accounts and then I've got this box. The box is a separate account. It literally has an account number. So adding the child to the account, or if you've got a trust, you retitle it to be owned by the trust, and you get that seamless, okay, trustee steps in and can now manage everything the trust owns. You get that with the box as well.
But they need to know where the key is. But that's a very common issue, is kids saying, I've looked through the entire house, I can't find their estate planning binder, I can't find this, I've been looking everywhere, like, and I know some people, they like squirrel it under a mattress or whatever. Like, please just tell your children where you or whoever your person is, like where your papers are. And then if we're your attorneys, that they have our card, they know that if something happens in an emergency, the power of attorney is here, this is where I find this is the attorney, I have her number to call us in an emergency. Those are going to be like the most helpful things to kind of make things easier. And one other sort of thing that's sort of related is that make sure your children or your people know like what assets you have, whether that's a list or something that you're keeping with your binder, or like an up-to-date list of assets. I've recently met with some family members that literally have no clue what assets their parents have or own, and the father is like totally, has Alzheimer's, and they have no idea, and we haven't seen them in like 20 years, so we have a list that's really outdated, and the kids are I'm trying to help the kids figure out what bank accounts still exist and what's there, and they're all stressed out trying to like take care of their dad and whatever, and they have no clue what the assets are. So like keeping an up-to-date list even just with your documents of like, okay, this is my financial advisor, this is where the bank accounts are, like basic stuff is going to make it so much easier for your family to be able to like take care of things in an emergency or when you pass away. And then of course, lastly, we always recommend that you work with an experienced estate administration firm like us or another office to help guide you and make the process smooth. And that's it.
If anyone has questions, just type them in the Q&A, or just, I think you can raise your hand. I think that's the feature too.
Yep, you can raise your hand or type any questions into the chat. If there's anything that you were sort of wondering and we didn't get to, please ask it now. Otherwise, you can, my email is here on the screen. If you think of anything after the fact, you can always send me an email message and I'm happy to answer any questions that might pop up later. And so thank you for joining. This is the last in our summer series, but like we said, we might do one in the winter on different topics. So if there's anything that you would like to learn more about that we haven't covered this summer, definitely let us know. And we're happy to, always happy to have new ideas on educational topics.
Thank you everybody for joining us. Have a great 4th of July.
Yeah, happy holidays.
Bye.